Hey everybody, it's Andy, and welcome again to my office in Los Altos, California. I'm an attorney licensed to practice law in California as well as New York, and in this video I'm going to go over the 5 questions that I think you should be prepared to answer if you are getting involved into a California residential landlord-tenant case. So specifically I'm going to talk about evictions. Landlord-tenant law as a practice area in California includes more than just that, but in my experience, at least in the San Francisco Bay Area, the overwhelming number of, requests or inquiries, the overwhelming number of prospective clients in the landlord-tenant sort of space are looking for evictions, either from the landlord side, like, landlords looking to evict tenants, or from the tenant side, tenants needing defense, let's say. So because of that, right now in this video, I'm going to talk about evictions only. Later on, if the demand sort of warrants it, I might record another video, another 5 questions video on other non-eviction types of cases in California. So anyway, hopefully that kind of established the ground rules about what this video is about. So let's go ahead and get started. So the first question that I think you should be prepared to answer is, well, to be honest with you, I think this might surprise some of you, but the first question basically is, what do you want out of this situation? So if you are a landlord, you should be prepared to kind of explain to yourself and to any lawyer that you are interviewing, for instance, what exactly do you want? Do you want the rent? Do you want the rent that this tenant has not paid you? Do you want the tenant out? Do you want the property back? Do you want all of that? Do you just want 1 or 2 of those, etc.? In my experience, this might be kind of specific to the San Francisco Bay Area, but a lot of the landlords that I've represented up here, a lot of the landlords that I've dealt with up here, a lot of times they are willing to waive small fees. So for instance, if you didn't pay rent for a month, they don't really, they want you to pay it, but the thing is, when push comes to shove, it is actually something that they are willing to let go in a surprising number of instances. To them, because I think, the rents in the San Francisco Bay Area are so high, it's actually much more worth it financially for them to basically waive small things and basically get the property back sooner, put a new tenant in it, and then, reap the $3,000, $4,000, $5,000, whatever it is per month. It just makes business sense to get the property back as quickly as possible, waive everything else in some instances. So conversely, if you are the tenant, you might have to kind of, explore, I guess, or kind of think to yourself what exactly it is that you want out of the situation. Some tenants, I will tell you, that like the ones that I've dealt with, sometimes they do want to stay. And unfortunately, I think a lot of those instances are ones that are not really sort of grounded in reality. Like the tenant, for instance, views it as their home, but it's really not, because it's just a rental, etc., etc. So ignore those kind of minority sorts of cases. I guess I wouldn't say it's the majority, but there's a lot, basically. There's a lot of tenants out there who are facing evictions where they agree to move, so moving out really is not the kind of the holdup. The holdup basically is that they can't move out in the time that the law normally prescribes. So if you've never been involved in a landlord-tenant case, it moves really quickly. Stuff that might take years on a kind of non-landlord-tenant case. In a landlord-tenant eviction case, rather, stuff that might take years otherwise only takes a few weeks or a month or 2 or something like that. So stuff moves really quickly. If you are a tenant and you lose a landlord-tenant eviction case, it might be something where you have to move out in 5 days. And realistically, a lot of times people can't do that in 5 days. Like they just have too much stuff. They have to pack it all up. They have kids. They have work. They have, to go find a new place. They have a U-Haul truck that they have to wait for, blah, blah, blah. So a lot of times, the dispute basically is not that the tenant won't move. The tenant just won't move in the amount of time that the law kind of prescribes. In those situations, if the tenant basically just needs more time, the landlord just wants to get the property back, is it possible that some sort of middle ground, some sort of compromise that kind of benefits both parties could be reached? Sure. I guess because I've done it a couple times already, like it's not surprising to me, but I can imagine, I guess, that it would be surprising to a lot of landlords or tenants who are going through this the first time. That compromise can be had, I guess. So anyway, that's kind of a really long explanation of the first question. So what exactly do you want out of the situation? Do you just want the property back? Do you want more time, etc., etc.? So that's the first question. The second question that you should be prepared to answer basically is what city or county is the rental property in? Obviously, that's going to be a really simple question to answer, hopefully. But the reason why that question is important is because if you are in a city or if the rental property is in a city or county that has additional rules on top of what state law requires, number one, that's something that you have to tell your lawyer because your lawyer might restrict on geography that way. I'll explain what that means in a second. But if you have additional rules, regulations, etc., based on the city and the county that you're in, you need to comply with those, of course. And you have to figure out what those are if you don't know them, etc. So on top of that, if you happen to be in a city or county that has a lot of rules that like most lawyers in your area don't know about, for example, because it's not something that's really worth it for them to kind of know. That's important also, and I'll give you an example. In the San Francisco Bay Area, the city of San Francisco, city and county of San Francisco, has its own rules and regulations about what what landlords and tenants have to do, basically. So those rules and regulations are specific to the city and the county. Rent control, I guess, if you've heard of that before. But specific rules that are specific to San Francisco, the city, and the county, unless you're a lawyer who takes eviction cases in San Francisco all the time, you're probably not going to know those rules. So, for instance, for me, I know the state law rules, but I don't know the city and county's rules, the city and county of San Francisco's rules, because I don't take cases up there with enough regularity. So if you were to approach me with a request to do an eviction or to defend an eviction in the city and county of San Francisco, I might have to, turn you down, or I would have to refer you to a specialist who does those types of cases in San Francisco all the time. Because they do it all the time, they know the rules way better than me, the occasional sort of like lawyer, I guess, who would do those cases. So hopefully that made sense. That's question number 2. So question number 3 is basically, are you on lease or off? And what I mean by that is, are you still bound by the terms of a written lease, 6 months, a year, etc., or has your lease basically expired and now you're on a month-to-month situation? So I guess if you ignore the landlord-tenant sort of scenario for a second, you can hopefully sort of imagine that if you are on contract of any kind, if you have a contract of any kind, and you're still bound by it, that basically imposes restrictions on your freedom. Like, you basically are not able to do the things that you would otherwise do normally. So if you are on lease, for example, and you're a tenant, one benefit could be that you have I guess your rent basically is locked. So let's say you sign a 12-month lease and your rent is specified as $1,000 per month for the entire 12 months. So if the landlord tries to raise your rent, you could say, well, excuse me, Mr. Landlord, I have a contract with you that says that my rent is frozen at $1,000 a month. At the end of this lease, this written lease, you can try to raise the rent, and at that time I might move, I might not, etc. So that's like if you're on lease, you're going to have some restrictions on your freedom. If you are off lease, you might have some restrictions on your freedom, but they're generally going to be a lot less. So if I go back to that rent scenario, if you're a tenant and your lease has expired, your written lease has expired, if the landlord basically tells you, hey, Andy, I'm going to raise your rent from $1,000 to $1,200, per month starting next month. In that scenario, I might go, okay, well, I'm sorry, but I really don't want to pay that. Tell you what, I'll give you my notice now and I'll move, and then next month hopefully you can advertise this and get another tenant in here who will pay that, for instance. So anyway, hopefully all that made sense, I guess. But if you're on lease or off lease, that kind of determines how much freedom you have to do things, and that freedom to do things, that's always going to be important in any type of scenario. So that is number, I think, 3 is what we're talking about. So number 4. What notices have been given in your situation and when were they given? So I have another video on my channel about 60 versus 30-day notices when you're trying to terminate a tenancy, a landlord-tenant sort of relationship. And I guess in that video I cite to a whole bunch of codes and about what the notices have to contain, what type of notices have to be given, etc. If you've never done a landlord-tenant case in California, those notices are basically strict compliance. If you do the notice improperly, if you serve it improperly, if you give them a 30 when they actually should have had a 60, etc., that all of that's going to be really important is what I meant to say. I've been in front of some judges who are basically really extremely strict on it. If you don't do the notice correctly, the judge will dismiss your case. If you're on the landlord side, for instance. And if you have your case dismissed, you basically lose the filing fee. You have to pay your lawyer to do the case again. You have to pay another filing fee, etc. So it just is I guess, if the notices are not done correctly, a lot of problems can happen. And depending on which side of the case you're on, those problems might work for you or against you. But in general, lawyers, I think, will want to know what notices have been given, when were they given, and so forth. Yeah. So anyway, the last kind of question, number 5, basically is, I wouldn't say it's a catch-all, I guess, but in landlord-tenant eviction cases, what's very, very common is for accusations to be kind of, slung back and forth, I guess. The landlord says the tenant broke this, didn't pay rent, caused a noise disturbance, whatever. The tenant says, oh, well, the heater didn't work, the air conditioner didn't work, the landlord didn't fix any of this stuff, etc. So accusations being flung back and forth, really, really, really common. So because they're very, very common, I guess, question number 5 basically is going to be, what evidence do you have? So if you're the landlord, let's say, and you're basically saying, okay, I'm going to break this guy's lease, I'm going to, evict him, etc., because he was, I don't know, manufacturing methamphetamine in the house, let's say. And if that's the basis that you're using, great. But I, as a lawyer, for example, I'm going to want to know, okay, what evidence do you have that he was doing this? Do you have neighbors, who are saying that? Do you have the police who are saying that, et cetera, et cetera? If you're the tenant and you're saying that the landlord didn't fix the air conditioner, that the landlord, didn't spray for termites, et cetera, like what evidence do you have that the landlord did not do these things? So I guess hopefully this should not be surprising to anybody, but evidence generally is going to be what's necessary when you go to court. So the judge is not going to just believe you that, oh, well, yes, I'm going to believe you that the landlord didn't fix this, or I'm going to believe you that the tenant was manufacturing methamphetamine. Just evidence in general is going to be really, really important when it comes to court. And it's something that, I think at least, you should be prepared to sort of provide to your attorney at the very beginning. I think in my first 5 questions video about divorces, I think I mentioned in there that, one benefit of, thinking through these 5 questions, one benefit of being prepared is that you basically come across as the more, as the client that's more with it. And if you're more with it, generally you're going to have a better time, finding a lawyer to help you out of whatever situation you're in. So hopefully all of that helped. To kind of summarize real quickly, question number 1, what do you want out of this particular situation? A lot of times, actually, what the landlord wants versus what the tenant wants actually are not mutually exclusive. It is possible to benefit both parties, give them what they want. It just takes some artful negotiation. Number 2, what city and county are we talking about? And that's because, again, there might be individual rules, ordinances that are specific to that county or to that city. Number 3 is, are you on lease or off? Do you have a written lease that's still in effect, or has the lease passed and you are on a month-to-month situation? And that's important because that will determine how much freedom you have to do things, regardless of whether or not you're the landlord or the tenant. Number 4 is, what notices have been given in the situation and when. And the reason why that's important is because there are a lot of strict compliance, I guess, sort of rules, where if you actually get to court and you haven't done the background properly, you haven't done your homework properly, you could have your case dismissed, for instance. And then number 5 is basically kind of the cop-out sort of question. What evidence do you have that actually backs up all the stuff that you're claiming? So anyway, hopefully all that helped. Again, these are just my 5 questions that I thought of when I was shooting this video. And it's something where if you have your own 5 questions, for example, leave them down below. If I included questions that you didn't think are terribly important, that you would have included other ones, leave me that stuff down below in a comment also. But again, hopefully this helps you, helps you be more prepared is what I meant to say. Helps you be more prepared as a prospective client, helps you find a lawyer faster, and ultimately helps you out of whatever situation you're in. So anyway, again, hopefully all that helps. Go ahead and comment, share, like, subscribe, all that stuff. And I will talk to you guys next time. Thanks.